Can you guys see the screen okay? Or
Yep,
is it in the swap?
I can see it.
It's not in the slide mode. Oh, there it goes. Okay.
There we go.
And it
And
looks like notes is turned back on again.
okay, let me try that part
That's
too.
annoying.
All right. All righty. I think we got a couple of more people coming in here. Admit all. All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of inherited property, clearing title, deferred property taxes, and other probate concerns. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Cecile Carlson. Also, on behalf of our presenting partners, we have Ms. Mabel Menifee with the Harris Central Appraisal District, Ms. Lisa Nelson with the Texas Legal Services Center, and Shay Pinkowski with the Harris County Tax Office, but also included in the partnership, we have the Harris County Attorney's Office, the Earl Carl Institute, and Houston Volunteer Lawyers. And together, we all make up a month of service. And basically, a month of service is the collaboration of all of our organizations coming together on a monthly basis to offer a variety of different workshops and resources and information to the communities that we all serve relative to asset building, asset protection, um, community empowerment, and the maintaining of generational wealth. Several years ago, we decided to collaborate and pool a lot of our initiatives together to try to get as much information out to the community as we possibly can, and to create a larger impact and reach more people. So we decided that we were going to come in person in one particular neighborhood and offer all of our workshops for an entire month, and then go to another neighborhood and then do the exact same thing, working our way around the city of Houston. But of course, due to the pandemic, we had to transition to an online platform, which in essence has been a gift and a curse, I guess you guys could say. It has allowed us the opportunity to reach even more people. That's the gift. But the fact that this has expanded so much over the last several years. There's been a lot more workshops that have developed from our initial collaboration till now, that more people now want us back in their communities, but it's almost impossible for us to do all of these workshops every month in so many different neighborhoods. So we're slowly trying to figure out how can we transition back into our in-person and online sessions at the same time. So do look for us to come out to you guys. And we're planning for October. I think we were just talking about to be somewhere in person if you guys are interested in attending another session or know of someone else that may find the information that we present here today to be beneficial, then we will be in person somewhere in October. So just be on the lookout for that. But this is your opportunity to have your concerns addressed, questions answered related to inherited property, whether someone passes away with or without a will, when they've got deferred property taxes after they've passed away, what happens after someone does pass. In essence, this is kind of like the part two of the estate planning sessions that we do have. The first part is always done the first Thursday of every other month, with this one being the second Thursday of every other month. The first part is about wills and estate planning, why do you need it, and how to draft your own documents. So that's kind of like the preemptive part, what to do to prepare in advance of your passing. But this is the part that happens when we go over everything that happens after someone passes away. Again, whether it's with a will, without a will, what's that whole uh, process like, and the issues that can arise when someone doesn't, how heirs property gets created, how people then tend to lose generational wealth because there are no plans that are put in place to help alleviate some of this strenuous legal issues that people have, also to help dispel those myths and things that people hear, that because you have a will, a lot of people think that there's nothing else that needs to be done afterwards. There is a process that it actually takes to transition ownership from one person to another. Although you may be legal and entitled to inherit, but there is still a process that needs to be done in order for you to actually get that property transferred into your name. And Ms. Lisa is going to go over all of that with you guys. There's going to be a lot of information that we're going to cover here today. Again, this is your opportunity to ask whatever questions that you have, because we do have the experts available here for you. But at the same time, we ask that you try to keep your questions to be as general as you possibly can, so that one, you don't divulge any personal detailed information. As we are on a live Zoom session, we do broadcast over on our social media channels, and we do record the session and send it out to the viewers to actually go back and watch again. So we want to try to protect your privacy as best as we possibly can. In addition to that, again, we're just on a public platform. We don't need the specific details of who passed away, where they lived, children that they had, what they left behind, kind of thing. So please don't provide us with that information. And also, due to the fact that the information that does get provided here today is for educational purposes only. We don't want to cross the line with trying to give you any legal advice, but we do encourage you all to reach out to all of our legal service partners, and we do provide their information and contact for you, so that you can reach out to them and apply for their services as well, that are free or very low cost to you guys. So without further ado, we're going to go ahead and get started, and we'll have everybody introduce themselves, and then we'll move right along into the presentation. Feel free throughout the presentation to type your question into the chat if you are joining us on Zoom. If you are joining us on our social media sites, then please feel free to type your question into the comment section, and I'll make sure that it gets read aloud at the end, or gets addressed at the end of the presentation if it's not addressed throughout the sessions as we go along. So do note, again, I'm kind of monitoring and watching both things at the same time, so that we can make sure that we get those questions addressed for you all. So we want to thank you all again on behalf of the partnership for being here this afternoon, and hope that you all receive the information that you intend to receive. Following the end of the presentation, we do ask that you just take just a couple of minutes to fill out our really brief survey, kind of let us know how we're doing, and include any information that you'd like to include, whether it's wanting more information about another kind of resource or service that you may need, or information about another session. If we don't currently offer it, then please give us your feedback and let us know how we're doing, and what you think. So with that being said, Miss Cecile, why don't we have you go ahead and introduce yourself first, and we can get started.
Sure thing. Thank you so much, Nia. Good afternoon, everybody, and welcome. My name is Cecile Carlson. I am with the Department of Neighborhoods, and we are one of the partners in the A Month of Service partnership. I'm just very grateful to our presenting partners, and I'm excited to begin this session today. Lots of very important and useful information. And like I said, grateful to all of our A Month of Service partners and to our presenters today. So I'll go ahead and pass it on to the next person.
All
Thank you
right.
so much.
Ms. Shay, why don't we have you and Ms. Mabel, and then Ms. Lisa, you can introduce yourself, and then we'll move on into your presentation.
Perfect. Hi, good afternoon, everyone. My name is Shay Pinkowski, and I apologize in advance. My camera's lagging a bit, so I probably won't have it on when I'm presenting, just so that it's not distracting. But my name is Shay Pinkowski, and I'm here with the Office of Annette Ramirez with the Harris County Tax Assessor Collector's Office. Really excited to be able to share some information with you guys today and be able to answer some questions if there are any. As Ms. Nia mentioned, please don't provide us with any personal information. Kind of the basic gist of the situation is typically enough for us to be able to help you, and if not help you directly, then at least be able to direct you to either a contact information or to someone who would be able to assist you a bit further. But I look forward to be able to speak with everyone today, and I'm going to go ahead and pass it on to Miss Mabel.
Thank you, Nia. Good afternoon, everyone. My name is Mabel Menifee, and I'm with the Harris Central Appraisal District. And I'm here to sort of assist in calling out some of the issues regarding clearing title property that have to do with real estate, with property, and also with the exemptions and property taxes, which is one thing that needs to be in the forefront of your mind if you're engaged in some sort of heir clearing of title property for heirs. And so we're gonna go over some of those exemptions. We're gonna talk about how they relate to making sure that you have clear title to the property. And a lot of it will be involved with exemptions. I may not be able to answer all of your questions today because exemptions is somewhat of a complicated subject in terms of all of the different conditions and ways that you can acquire them, but rest assured they are important and one of the best ways for you to save money on property taxes, which is why you really want to make sure you have all of that information if you are in the process of clearing a title. So, with having said that, I look forward to talking with you in a little bit. I also have with me my colleague Anitra Collins, who can also answer any questions as it relates uh, to the types of appraisals that HCAD performs. So I appreciate it and look forward to talking with you soon. I'm going to turn it over to Miss Lisa.
Thank you so much, and thank you everybody for being here today. My name is Lisa Nelson, and I'm a staff attorney from the Texas Legal Services Center. So let's go ahead and get into my presentation. I'm really proud. I've been a longtime member of this partnership, and it's always great when we get together.
Okay. Again, as a reminder, please feel free to type your questions into the chat, and we'll be addressing all of your questions when we get to the end. Swap view, Miss Lisa.
Thank you. It does this every time. There we go. Thank you.
All right.
So we're here today to talk about clearing title and other probate concerns. I like to start with an overview of the probate process in general. Y'all have had the great presentations from Lone Star about how to have your estate plan, and this shows what happens, why it's important, and how to see it in action. I am a staff attorney at Texas Legal Services Center that's been around since 1981. We're a statewide organization that has a very broad service area. And our mission is to ensure equal justice for all Texans by educating, empowering, and representing vulnerable people while reshaping the greater legal system that impacts us all. And I'll share my email information in the chat afterwards as well on our website. So let's start by going over basic vocabulary that you'll be hearing as I go through the presentation. Decedent is the person who died. Intestate is someone who passes with a will. The person and their estate are called intestate if they pass without leaving a valid will. And what I mean by valid will is that the will is compliant with Texas laws. Dying with a will doesn't mean that the will meets all the legal requirements that we have here in Texas. Testator is both the testate estate as well as testator is the person who signed a will. And will is a legal document which states how the testator's property is to be distributed at death. Probate is a general term for the court process. It applies whether there is a will or not a will. It's kind of confusing because it's called the probate court, and that applies no matter whether there's a will, no will, whatever the situation is. But probate is also what happens when you apply for probate when someone passed away with a will. So the estate is the property, both the real property and the personal property owned by the person at the time that they passed. And if there was no will, the legal term is administration. So the process happens in the probate court, but your attorney would file an application for administration if there was no will or the will wasn't compliant with Texas law. I try to use the catch-all term personal representative. That's the person who is responsible for wrapping up the affairs of the person who passed and distributing the assets. If there's a will, that person is called an executor. If there was no will, the person is called an administrator. Heir and beneficiary are two terms for the people who inherit either through the will or by the by Texas law. There's a lot of common mistakes. Somebody's hairdresser's cousin knows all about probate, so you know that they're right and not this attorney that's talking to you. So it's important to understand a lot of the basics. For example, powers of attorney are only valid when someone is living. Once someone has passed, power of attorney is void. A surviving spouse has a life estate and the deceased person's home, even if it's separate property. So this is a really common misconception. A lot of people think, well, I don't need a will because, we're married, so the house will go to whoever is the survivor. That's not necessarily true. If the home truly was community property, yes, with exceptions. And I'll get to that in a minute. But if the house was bought prior to the marriage and it remains separate property, the surviving spouse does have a right to live in that person and the deceased spouse's home for their entire life. They have that right. It's called a life estate, which means they can live in the home until they pass as well. However, the surviving spouse is responsible for any loans, property taxes, and maintenance. As Ms. Nia said, if there is a will, you absolutely have to go through the probate process. Having a piece of paper that says, I inherited the house is not sufficient. You need to go through the probate process, have it go through the court, and then have it filed in the deeds office. When you appoint an executor, or if someone passes, an administrator is appointed by the judge, they have to be over the age of 18, and it's best if they live inside the state of Texas. It's also important to remember that children under the age of 18 cannot inherit. It's really important when you have a will that you let preferably your executor, but someone that you trust know where that original is. If they cannot find your original will, the law presumes that you tore that will up and did not intend for it to be probated. I'm always going to recommend that you have an attorney prepare your will. Forms that you download from websites are not always valid. The problem is that those are written as broad as possible to work in all 50 states. And Texas law has very specific language that has to be used in the will. So using something that you downloaded because you didn't want to pay for an attorney can end up costing your family quite a lot if it is not compliant with Texas law. That being said, our website, texaslawhelp.org, does have forms that the Texas Supreme Court approved for people to do their own wills. If you use that form, it is okay. Don't use any other forms. Don't fall for the people that for $100, I'll give you a will, or hey, use this software and you can get a free will, because those might not have the language needed in Texas, required by Texas law. Spouses must have separate wills. I have come across wills that both spouses, it's usually handwritten, which is valid in Texas, and one of the spouses wrote everything out and then they both signed it. That is very difficult to use. You do need to each have your own will. Now, as I just said, Texas law does allow you to handwrite your will. It's known as a holographic will, and we have information on how to do that on our website, Texas Law Help. It's really important to have a legally valid will because if you pass without one, the law determines who inherits your property. If you cannot find a will, your attorney can file an application for administration. This is one of the reasons why Texas law requires an attorney, is because there are numerous ways to go through the probate process, and an attorney knows the best way to proceed. So if there's no will, the attorney files an application for administration. It can be either independent or dependent. It depends on the circumstances, and I'll go through that in a few minutes. There are extremely limited cases where you can file a small estate affidavit. That is the only probate process in Texas that does not require an attorney in most counties. In Brazoria County, they even require an attorney for small estate affidavits, and I'll explain those circumstances in a second. The main reason why you need an attorney is because only licensed attorneys can represent yourself. In most probate cases, you're not representing just yourself. The personal representative is representing the interests of heirs, creditors, and the estate. So they're representing a lot of people, and you cannot represent anyone besides yourself. The only situation that is a narrow exception is if you qualify for a small estate affidavit. In the majority of counties, you won't need an attorney. Also, there is very new law in Texas where it was a court decision that allowed somebody to not have an attorney because she was probating a will as a muniment of title and she was the only heir. And a muniment of title, I'll go into detail in a minute, but it's basically when the only thing you need to do in the estate is transfer some real estate. Now, this gets confusing because a lot of people think, well, I can represent myself in a divorce. I can represent myself in all other kinds of lawsuits. That is because you were truly only representing yourself. It's just like if you own a business, you have to have an attorney because the business is a separate legal entity. In this case, the estate is a separate legal entity with its own tax ID number. Texas has what's known as probate assets and also non-probate assets. So probates are anything that pass through a will, and that could be real property, your home, and your personal property. So all of your stuff can pass through probate. The exception is there are assets that are not non-probate that can be transferred through a contract. This would be like life insurance proceeds, retirement plans, and payable on death accounts. Those do not need to go through the probate court if they have properly named beneficiaries. So one of my tips anytime anybody asks me about a will or if they should have a trust, in Texas, if you have payable on death beneficiaries on all your financial accounts and a transfer on death deed for your home, your family probably will not need to probate your will. So if there is a will, or if you qualify for independent administration, the first thing that happens is the attorney files an application. It's either an application for probate or an application for independent administration. They file that with the court. After 10 days, the attorney can schedule the hearing. This does not mean that you will go to court 10 days after your attorney files their application. In Harris County, it can be 6 months. I haven't practiced in the probate courts in a little while, but it's not unusual for it to be 6 months or more. Even though we have 5 probate courts here in Harris County, they are really busy. So what happens is the attorney and the person who has applied to be the executor or independent administrator has a very brief court hearing. And if the judge grants the application for probate, the personal representative receives letters. If there is a will, the personal representative receives letters testamentary. If there's no will, they receive letters of administration. It is then the personal representative's responsibility to gather all the assets owned by the deceased person and to open a bank account for the estate. Once someone passes away, within a couple of days, the bank closes the account. This sometimes even happens if it's a joint account. It depends, but in general, expect it to be closed within a few days of that person passing. Once someone is appointed the personal representative, they take the letters that the court granted, as well as the death certificate, and they can withdraw all the money from any accounts that the deceased person owned and open up a new account in the name of the estate. This is where they also need to get a tax ID number for the estate. People who inherit, especially the personal representative, are absolutely not responsible for the debts that the person who passed had. There is a legal process that has to be followed. The attorney notifies any creditors to the estate, and they have time limits in which they have to file a claim against the estate. And then the last thing that happens, if there's a will or if there's independent administration, is that the attorney and personal representative prepare and file the inventory. The inventory is a list of everything that the person who passed owned as of the date of death. If you have a good valid will and nobody files a contest, it's a very easy procedure with limited court involvement. Now, I always have to say if no one files a contest, because I can't tell you how many times I have heard, oh, my children never fight. Everybody gets along. You do not know how people are going to act after they pass away. And I can tell you from personal experience, it can get ugly and people get greedy if money's involved. So you do not know, all kinds of old family dramas come to play, and it can get bad. So you really want to make sure you have an airtight will. But if nobody fights and there's a valid will, you go to court for about 5 minutes, and the judge will announce that they are admitting the will to probate and ordering the issuance of letters testamentary. Those letters are an official document that gives the personal representative the right to manage the estate. And then, like I said, the attorney notifies both beneficiaries of the will and creditors. And then the attorney and the personal representative file an inventory. You can also file an affidavit in lieu, which basically is just a statement that all of the heirs are aware of the estate's property. And then you don't have to list everything that the person who passed away owned. With an application for independent administration, it is almost as smooth as if someone passes with a will. An independent administration requires that all of the heirs are over 18. They all have to agree, and they file waivers with the courts stating that they agree to an independent administration and agree that the person named in the application can be the administrator. The hearing is still relatively simple. It's usually less than 15 minutes. The judge appoints an independent administrator and orders issuance of letters of administration. And again, that's the official document that gives them the right to access all the assets and manage the estate. And again, the attorney notifies beneficiaries and creditors, and they prepare the inventory. Everybody wants to avoid dependent administration. It is very expensive and very time consuming. It requires strict court supervision. So if somebody fights and doesn't agree to an independent administration, or if someone is under the age of 18 or otherwise disabled, the attorney has to file an application for dependent administration. The dependent administrator has to post a bond. It's usually about 10% of the value of the estate. Every single action requires court approval. I had a case where someone passed without a will, and one of her children was not an adult yet, so we had to have a dependent administration. We had to get court approval to have the lawn mowed. We had to get court approval to keep all the utilities on in the house. We were constantly in and out of court to get the judge to approve every action. There is one exception. If someone passes with a significant amount of debt and they don't have a will, the dependent administration will provides more legal protections and very strict deadlines so that it's harder for creditors to collect any funds owed. Now, if someone passes without a will, they also have to the attorney also has to file an application for determination of heirship. It's required for both independent and dependent administration. If there's no will, you and your attorney have to prove to the judge that every single heir was included, that you haven't left anybody off, that there isn't anybody unknown. So the judge appoints an attorney ad litem, that is an attorney who is considered a neutral party, who is there to represent the interests of any unknown heirs. And the attorney ad litem does research to investigate the family history, and they also speak with 2 disinterested witnesses. Those are people who knew the person who passed very well, but who do not legally inherit. There is a hearing that's usually less than half an hour because both the attorney ad litem and the attorney for the estate have to get the testimony of both the person who is the personal representative, as well as 2 people who can vouch that we have included every single relative. Nobody's been left out. And then along with the order allowing appointing someone to be an administrator. The judge signs an order stating who all the heirs are and what their shares and interests are in the estate. If the only thing you need to transfer is a house, which is not unusual, you can use a process that is probating a will as a muniment of title. It is also the only exception when you can file for probate more than 4 years after someone has passed away. Texas law requires that the probate process happens within 4 years of the date of death, unless there is an excellent reason why it wasn't filed on time. The best example I heard about this was someone who her husband had passed. She had no idea that he had a will. And many years later, she was selling the house and she came across a safe in the garage. And once they got a locksmith to open up the safe, they found a will. So she went to court and explained to the judge, I had no idea that he had a will, so I didn't even think about filing for probate. And the judge will grant and allow you to do so in situations like that. So a muniment is a legal term for a document, title, deed, or any other type of evidence that indicates ownership. So this can only be done if there's a legally valid will. And just like administration, everybody, all the heirs have to agree to probate the will. When you go in front of the court, in front of the judge, your attorney will explain the only thing we need to do in this estate is transfer the ownership of the house. There are no debts that need to be paid except for debts related to the house. And this is all we need to do is clear title to the property. The judge will admit the will to probate. They will not appoint an executor. What happens then is your attorney would record a certified copy of the signed order along with a copy of the will and the deed records, and that will transfer the property to the person named in the will. Like I said, there is one Texas Supreme Court case that came out last year that allowed someone to file pro se, which means she represented herself because she was the only person named in the will. Small estate affidavits can get really confusing. If you go to the clerk's office, court clerk's office, they're not attorneys, so they don't know. And you go in and you say, my loved one died and they didn't have a will and I don't have an attorney. I don't know what I need to do. And they'll say, oh, here, file a small estate affidavit. You can only use it in very limited circumstances. It can only be used to transfer real estate if it is a surviving spouse or child under the age of 18 who inherits the home. An adult child cannot transfer property through a small estate affidavit. It is not valid in that case. All of the heirs have to sign the small estate affidavit along with 2 disinterested witnesses, and it cannot be used if the deceased person had a will, had a legally valid will. And the other issue is that the assets must be greater than the debts. For example, and this excludes any mortgage, any debts against the house, any other debts. So if someone passes and they had $20,000 in assets, but they had $50,000 in debts, the judge cannot sign the small estate affidavit. Also, the estate, excluding the homestead, must be less than $75,000. And again, most counties in Texas allow you to file a small estate affidavit without an attorney. I have been trying for quite some time to find a list of all those counties and have not. I do know in Brazoria County, you have to have an attorney, and there's a rural Northwest Texas county that isn't coming to mind right now. Everybody wants a trust. I always joke, I wish I had the PR that a trust had, because everybody thinks that a trust is the best thing in the world. I don't want my family to go through probate. I want everything to be in a trust. It's a lot more complicated than that. And I always joke that my superpower is explaining to people why they don't need a trust. So a trust is just like a will. A trust is a legal document that states how the testator's property is to be distributed at death. It can transfer everything, both real and personal property. One big issue with trusts, if the property hasn't been properly transferred to the trust, that trust is just an expensive stack of paper. A lot of people will go online to do their own trusts, and they don't understand that just writing the trust isn't enough. The house has to be deeded in a very specific way. All of the property, it's very complicated to transfer property to a trust, which is why it's extremely expensive to have an attorney prepare a trust for you. But if an attorney doesn't prepare your trust, it's probably not going to be valid. One big example is a lot of people don't understand that you have to deed your house from yourself to the trust. And if it's not done correctly with very specific wording, you can lose all of your property tax deductions. There are a couple of good reasons to have trusts. A lot of people use trusts to protect their assets so they can qualify for Medicaid to pay for their nursing home. Trusts also allow you to have control after your death. If you have a child with special needs, if you have young children, you might want to have a trust. The other reason is if you're in a blended family and you want to make sure that your kids get your things, the other spouse's kids get that person's things, and you don't want anybody to be left out. That's a reason to have a trust. If everything is owned by a trust, and that means correctly transferred from you to the trust, probate court is not necessary. And I have to say this again. If you correctly name beneficiaries to all of your financial accounts and use a transfer on death deed for any property you own, your family can avoid probate. So this comes up quite a lot because a lot of people don't understand that you have to go through probate. Just because something is a family home doesn't mean that the next generation automatically owns it. So if you don't have clear title, you will not qualify for any type of disaster assistance. When I was at the Earl Carl Institute at TSU, a lot of work was not needed when we would have a hurricane or a winter storm, and people would find out that nobody really owned that family home because they didn't have clear title. So they would have to come to us. We would go through the court process to clear title, and then they would apply for FEMA or any of the state assistance programs. Additionally, you are not eligible for property tax exemptions or deferrals if you are not the owner of record. So clear title means that no one else has an interest in your property. It also means that the ownership history is clear, that there's not any question of who owns the home. So if property isn't legally transferred or deeded to the next owner, the title is called cloudy. This can happen when somebody dies without a will or when the family doesn't know that they needed to probate the will. Title is the legal right to the property. It is not a piece of paper. It is just your right. It's your right. You know that you own that house. The deed is the piece of paper that shows, that conveys that right to you. So title is the strength of your ownership claim. So having clear title means that there aren't any unexpected claims on the property, such as a lien. A deed is a document that is used if you sell your house to somebody else. So it's really critical to have clear title, as I said earlier, for property tax relief and recovery assistance from a disaster. But also, if you don't have a clear title, you can't get you won't qualify for home improvement loans or any other type of loan. So if you don't probate, and this is really common that people don't know that you have to go through the probate court. If you don't go through probate, you probably do not have clear title, and you probably will not be able to access any bank accounts. So there's a few ways to go through the court to clear title. If it has been within 4 years since the homeowner passed, you go through the probate court. If it has been more than 4 years and there's a legally valid will and everyone agrees, you can file an application to probate as muniment of title. There's one more way to clear title through the court, and that's a petition for adverse possession. So going through traditional probate, the judge determines whether the decedent left a will that is compliant with Texas law. And if there wasn't a will, the attorney will file an application for administration. If you're the surviving spouse or there's a minor child, you can file a small estate affidavit. So again, as a reminder, if it's been more than 4 years and you have a very good reason why you did not probate the will, you can go through filing a probate application for probate as a muniment of title. And then once you go through probate court and the attorney gets certified copies of the order, that along with the will are filed in the real property records of the county, and the title is clear. Small estate affidavit is terrific if you're a small surviving spouse. Everybody has to agree. All the heirs have to agree and sign the small estate affidavit. And it has to be signed also by 2 disinterested witnesses. This is the one probate process that doesn't require a court hearing. You or an attorney files a small estate affidavit and a proposed order. And if all the elements of the law are met, the judge will sign the order and you're good to go. Your title's clear. Adverse possession, everybody's heard about in one way or another. It's a legal principle that allows a person to obtain ownership of a property based on continuous occupation without permission for a specific length of time. If you have permission to reside at that property, you cannot meet the elements of adverse possession. It's called adverse because you have to be occupying it adversely. And the length of time varies. There's several different laws, but it's usually around 15 years. This is the situation where one of the times that I filed an adverse possession case, the surviving children found out that their parents never had clear title. Something had not gone right when their parents bought the house from the prior owner. So we had proof. Oh my goodness, they'd been living in that house for more than 50 years. And so we had proof that they had been living there without permission for a significant amount of time. And it took some time, but we were able to get it resolved. And another situation is a lot of times people will live next to a vacant lot and they'll decide to keep that lot clean. They'll cut the grass. Maybe they'll put a garden on it, let kids play on the yard. And everybody in the neighborhood knows that's Miss Brown's property. And you prove that, you have witnesses who prove, oh, Miss Brown has kept that yard up for 20 years. All the kids in the neighborhood play on that yard. And you're able to get clear title through adverse possession. There is a way to clear title that doesn't require going through court. And it also doesn't require an attorney. It's called an affidavit of heirship. And it's a legal document that gives property to the heirs of a deceased person. It's often used if the homeowner didn't have a will or if the will wasn't probated within 4 years. Ownership is transferred to all living heirs. So all the children or all the grandchildren, depending on how long it has been since the owners passed away. It's basically a family tree that lays out all of the marriages, all of the children, if children have passed, who the children's children were. And it has to be signed and notarized by 2 people who knew the family history well, but not the people who legally inherit the house. You must include the full legal description, which is found on the deed. You cannot use the legal description on the property tax bill. And again, this is filed in the county where the property is located. There is a small filing fee. It's a lot less expensive than probate, but there is, I think in Harris County, it would be roughly $50. The other counties are usually less expensive. And it does have to be recorded. And when you file an affidavit of heirship, it gives title to all living heir. I had a case where ancestors, I think it was like 1905, had purchased some property in East Texas. And by the time that the heirs realized that they didn't have clear title, they were, I'm not even going to be correct, probably 5 generations from the ancestors. And there were there were more than 20 heirs. And there were several of them who didn't want to inherit that property. They didn't want to deal with the property taxes. They just didn't want to deal with it. And what they did is they filed deeds giving their share to the person that everyone agreed would inherit it. Okay, it gets confusing because we talk about small estate affidavits and affidavits of heirship. Small estate affidavits are only used to transfer real property to a surviving spouse or children under the age of 18. If you are a surviving adult child, you can use the small estate affidavit if all you need to transfer is something like a bank account. You want to be sure and talk to the bank or whatever type of financial company you're dealing with and make sure that they accept a small estate affidavit before you file it. Affidavit of heirship is the best way to transfer a home to surviving spouse, adult children, or other relatives. And you can use an affidavit of heirship instead of probate if the home is the only estate asset. Every time I help people clear title, I'd say, let's be sure that this doesn't happen to your kids. Let's make sure that we keep this clear going forward. A relatively new law in Texas is a transfer on death deed. And it's a very inexpensive way for you to transfer your home to someone else upon your death. It does not affect your rights during your lifetime. You can sell the property. You can use it to get loans. You are qualified for tax exemptions and deferrals. The people you name in the transfer on death deed have no rights until the owner passes. The owner also can cancel the transfer on death deed and change the beneficiaries or not have a transfer on death deed at all. The one very strict requirement is that the deed has to be filed before you pass. So don't keep it in a safe place with your will. Take it to the county property records and file it. Ladybird deed has been around in Texas for a very long time. I think it's valid in about 12 states. It's also called, the official title is Enhanced Life Estate Deed. The TOD, transfer on death deed, is covered by a Texas law, a statute. Ladybird deed is not. The one benefit of the Ladybird deed is it can be signed by someone holding your power of attorney. So if someone's parent is incapacitated due to dementia, the person who is the agent acting under the power of attorney can sign a Ladybird deed. Oh, they're accepted in 5 states. And one great thing about TODs and Ladybird deeds is it exempts you from Medicaid estate recovery. You'll get a recording, so I'm not going to go through all of this, but this is a comparison of the TODs and the Ladybird deeds. Benefits of the TOD, it is governed by the Texas Estates Code. Also, you can have more than one beneficiary. You can have all your kids if you want. You can also include it always includes alternate beneficiaries. So a common thing in a TOD is that spouses will leave it to each other and then say, after the second spouse passes, we want our children to get it. You cannot do that in a Ladybird deed. TODs can trigger issues with mortgages. But TOD, you have to have the capacity to sign. The Ladybird deed can be signed by a power of attorney. And one thing that's an issue is if there are any claims against the estate, the house transferred through a TOD may be subject to creditor claims. Another Medicaid estate recovery is the program in which if people receive Medicare, once they pass away, Medicaid can look to reimburse itself for the expenses. They only do that after a surviving spouse also passes. When applying for Medicaid, at this point, there is a 5-year look-back rule. That means that when you apply for Medicaid, the Medicaid people go through all of your finances with a fine-tooth comb, and you cannot have transferred something within 5 years of the application. The exception to that is a TOD. The Medicaid authorities have said we're not going to penalize people who transferred a house through a TOD, even if it's been within the last 5 years. The Ladybird deed, on the other hand, has to be prepared more than 5 years before applying for Medicaid benefits. So I beg all of you to have a transfer on death deed. You need to make sure you have a legal description. Get it from an existing deed. If you do not have a deed, contact the county clerk's office and you can order a copy of your deed. If you use the description from your property tax bill, it will be incomplete and the transfer on death deed may be invalid. I can't tell you how many times I have given talks about how to do a transfer on death deed, and I will explain multiple times you have to get the property description, the legal description from your deed. Someone will come up to me after my talk, show me their TOD, and it has the tax description. That is not valid. It's very confusing because your tax bill says legal description. That is only valid for property tax purposes. It is not valid when you're preparing a deed to clear title. We are lucky in Harris County, and most of this applies to Fort Bend County as well, to have a wealth of resources. Our website, Texas Law Help, the Hotline for Texans is a program for Texans over the age of 60 or on Medicare. Earl Carl Property Preservation provides assistance with anything to do with housing. Lone Star Legal Aid, Houston Volunteer Lawyers are great other options for free legal service. Legal Line, held by the Houston Bar Association, is a place where anybody, regardless of income, can get free legal advice. And if you need help finding a lawyer, call the Houston Lawyer Referral Service. They also maintain a list of attorneys who will accept reduced rates. Thank you so much for your time. I will stick around for questions after my friends at the Central Appraisal District and Tax Assessor's Office are finished. Have a good afternoon.
Right. Thank you, Miss Lisa. Miss
Thank
Mabel,
you.
Oh,
you are up.
okay, let me share. Okay. Is it up there?
Nope, not yet. And I see that there are two questions that are in the chat, so we'll go over those when we get done with the presentation. And it's up. If there are any other questions in the meantime, please feel free to type your question in the chat, or you can wait until the end and unmute yourself and ask your question directly of the presenter. Yeah.
All right,
All
how's
right.
that?
You're all good.
Okie dokie. Good afternoon again, everyone. As you just heard, a lot of good information from Lisa about clearing title, and I'm going to touch on a few of the things that she said as it relates to going through the going through the wills and probate process, and where you might encounter issues or questions about property taxes and how that all plays into clearing title. So just briefly, we are the Harris Central Appraisal District, and we are responsible for administering not only property taxes, which I'm sure everyone knows supports local services, firemen, police, etc. And one of the reasons property taxes play such an outsized role here in the state of Texas is because Texans have elected to not have a state income tax. So therefore, the most of the local services are used, tax revenue is used to provide those local services. Believe it or not, there are about 600 there are over actually 600 taxing entities in Texas. And depending on where you live, where you reside, you would probably be paying to 4 or 5 of them, or maybe a couple of more. It just depends on where you are in the county and what those are. And again, property taxes originate with the state legislature. We operate under the Texas Property Tax Code, and also the state organization that has oversight for appraisal districts like HCAT is the Texas Comptrollers. Again, the role of the central appraisal districts like ours is we value and appraise all county property, whether it's residential, commercial, agricultural, industrial, or something called business personal. We also, another important function of one of the huge functions that we do is administer the exemptions for property owners. We also certify the appraisal rolls. Our goal is to keep the system fair so that all of the taxing jurisdictions go by one value. That is the value that HCAT assigns to the property. And just a little bit administrative wise, we are overseen by a chief appraiser. He's sort of the CEO of our district. And we also have a 9-member administrative board. You can find that information out on our website. And this is primarily the annual value notice. If you're looking in relatives, a deceased relative's paperwork or whatever, you may see this. This is their annual value notice that they receive each year from HCAD, and it includes the appraised value of the property, and it also includes the market value of the property. The market value is what HCAD determines each year, and that's the value at which a property would sell to for a willing buyer on the open market. You'll also see something called appraised value, and the appraised value could be the same as the market value, but it's often lower. And why is it lower? It is because of the exemptions that may have been applied or attached to that property. And so that's what we're going to get into next. Just some important dates. I wanted, one of the reasons that it's important to kind of understand what exemptions and how the property tax system works is because there could be some deadlines because the appraisal calendar operates on an annual basis. So sometimes if you miss a deadline, you may miss out on some savings or the ability to have an exemption for that particular instance. So let's get into those exemptions and what are they and what you might run across, how they typically, most people want them because they save them money and they're not overpaying for taxes. What they exactly do is they exempt a portion of that property's value from taxation. And when we talk about residential property, it is for exemptions are, in this case, for our purposes today, are about for the primary residence only of a property owner, typically the place where they live and reside. And these exemptions are what are used again by all of the taxing authorities that you pay to for calculating your property tax bill and providing the appraised value. The most common that someone is going to have, if you're a property owner, you're going to have, or you should have, a general resident homestead exemption on your primary residence. The other main ones that we're going to kind of go over a little bit quickly are the over 65 exemption. That's in addition to the general resident homestead. Over 55 surviving spouse exemption, disability exemptions, certain special disabled disability exemptions that are available for veterans or their surviving spouses, and then a couple of other service-related and disaster-related exemptions. The general resident homestead is what anyone in their primary residence most likely has. In order to get that, they have, and the thing that's most important about that are the savings that a property owner would have if they had that exemptions. For instance, the $140,000 school tax exemption, and that's by state law. That is in any county in Texas. Meaning, what does that mean? Essentially, if your home is a $300,000 home, well, that first $140,000 in value is exempt from taxes. So that person with that exemption, which may be in this case a deceased relative, their tax bill is going to reflect that $140,000 school tax exemption. There are other exemptions that different jurisdictions, the city, the county also offer for the general resident homestead exemption, kind of depending on where you live. And I think Shay, my colleague, who's next from the tax office, is going to talk a little bit more about those. But remember, those exemptions there may be property that those exemptions have been applied to because that person had qualified for those. One of the things that's important to remember when we talk about exemptions is that the exemptions are based on the qualifications of that person, of that individual. They aren't attached to the property. They're attached to that individual's, that homeowner's qualifications. So that's an important distinction when property is changing ownership, because those exemptions may not apply to the person who is who is taking over ownership. And if they do, are eligible for them, then they would have to apply for them themselves. Those exemptions are going to roll off that belong to that person can roll off at the end of the year, come January. Sometimes it's important to know that this, unfortunately, it's not something people tend to think about a lot when they're inheriting property. And sometimes that can eventually result in back taxes because you were living in a home and receiving exemptions that you were not eligible for. So let's look at some of the other ones in order to be aware of that. That is the over 65 and disability exemption. We group those together because essentially they provide the same benefits. You can only have one or the other, however. So the over 65 exemption, you qualify for it the year that you turn 65. So if you were to turn 65 on December 30th of this year, you would still get that benefit for all of 2026. You get that exemption. Additional benefits that you can expect for that is an additional $60,000 exemption for school taxes. That means that on top of the $140,000 exemption you already had as your general resident homestead, you also are going to get an additional $60,000. So again, that's a significant savings. Also a significant liability if you're living in a home where you have just moved in and are not eligible for that exemption. So you're also eligible for something called a tax deferral at over 65, and you can pay taxes in installments without any penalties. The additional exemptions, again, depending on where you live in the county, can provide you with additional exemptions based on whether it's city, county, school district, community college, or whatever. You can also get some special payment options that are going to be offered by the tax assessor collector, which Shay will discuss in a minute. The disability exemption is something that you would qualify for. You do not have to be 65 in order to qualify for it if you're 100% disabled. You can qualify for that under the Social Security Federal and Survivors Disability Insurance, or some people may not be on Social Security, so you can apply for that through HCAT with a physician statement that we can provide to your physician, and they would send that in certifying that you were disabled and unable to work. The other most common exemptions are the over 55 surviving spouse exemption. This is an important one in the event that if a deceased spouse had qualified for the over 65 because of course they were over 65, or for the disability exemption, and they pass away, the surviving spouse, as long as they are at least 55 years of age or older on the date of the spouse's death, can continue to keep those benefits and nothing is interrupted. They'll receive all of those over 65 benefits. The veterans exemption, there are a number of those, as you can see on the screen: total VA, total disabled, and then including some for the surviving spouse. The immediate resident homestead exemption, just something to know in terms of when you move into a new home. That one allows you to prorate your taxes for the year. There used to be a time when you could not receive an exemption, or it would not become effective until January of each year. However, now that if you move into a home, you can qualify, especially if it's a new home or it's been a home where the previous owner did not have any exemptions, you can receive it on a prorated basis. For instance, if you're moving into it in March, which is the 3rd month, then you could get prorated exemptions based on the 9 months that you lived in the home. Airship exemption. This is one that want to take a little bit of a dive into. As Lisa talked about, the heirs and probating, and a lot of times there's no clear title if a parents want to leave the property to their just their heirs and not one in particular. That is kind of what describes this. And what happens then is, in a lot of cases, there may only be one of the heirs living in the property, not all of them. Other brothers and sisters let's say, may be out living in another area of town or moved out of state or whatever, they have their own homestead exemptions on their property. However, the heir that's living in that property, because they don't have clear title, may not be able to get an exemption in order to save money, even though they are the ones living in the home, they're taking care of it, maintaining it, etc. There is a way that they can get the exemptions on the property, uh, saving money on paying their taxes, of course, but without affecting the ownership rights of any of the other heirs. And that's what I want to talk about briefly now. The heirship exemption is something that you can apply for at HCAD. It is part of the exemption application process. And when you fill that out, once you get to section 3 of the application, that's when it's going to ask some specific questions about whether or not the property is an heir property. Should you check yes, as you can kind of see the question asked down here in the highlighted portion, and then do other heir property owners occupy the property? Yes. Then there are going to be some additional requirements that and information that HCAD will need in order to process that as an heirship exemption. And that includes answering several questions, providing that affidavit of heirship that establishes that person's interest in the property. We're also going to need the death certificate for the prior owner of the property, as well as a copy of the property's most recent utility bill. Why do we need that? Essentially just to make sure that the property is being occupied, and then citation of any court records that you can find related to your ownership of the property if available. And this is with this information, we be able to process that heirship application for you and hopefully get you that 100% of the exemption. The one thing I wanted to mention to you now, just because we're getting, as there are a couple of new exemptions if you're a homeowner or about to be one. One is the new one for 2027, which is a temporary exemption for a resident homestead that has been destroyed by fire. Previously, again, if your appraisals are based on the condition of the property as of January 1st. However, and if you had a fire on January the 3rd or the 5th, whatever that property condition was on the 1st, that's what your taxes would be based on. Now, when we come back around to the next January the 1st, and you have not been able to make any repairs, the situation hasn't improved, that's when you would see a reduction in your taxes for that following tax year. However, the legislature passed something called the temporary exemption for a home destroyed by fire, which comes with certain conditions. For instance, the home must be rendered uninhabitable for at least 30 days. You're going to have a deadline in order to file for this. However, you can now get a prorated exemption based on the fire disaster. So that's something that's again is going to be new for 2027. So keep that in mind. If you have neighbors that might have issues, those applications will be submitted to HCAD and be reviewed by our appraisers. If, for instance, for some reason you may be denied that, you have the opportunity to protest just like you would with your normal property valuations. The temporary exemption the other temporary exemption that you may already be aware of is the one that is for properties damaged by a declared disaster. For instance, that one came into force by that was enacted by the legislature just in time for Winter Storm Uri, which they initially set this exemption up thinking of hurricanes and those types of natural disasters that the Gulf Coast sometimes experiences. And lo and behold, the first time it was administered, it was for a winter storm. So, but some of the things that that one has to meet is that you have to have a 15% damage threshold. That means at least 15% of the property has had to have been damaged. You can apply for that again, just like you will be able to do with the temporary exemption for fires. You can apply for that on the HCAD website. The Texas Comptroller also has some generic forms that appraisal districts will accept. And then property owners, you have 105 days after that declaration of disaster by the governor, the president, or whoever does it. You have 105 days after that to actually file for that exemption. So those are some of the main exemptions that you might want to be aware of, either if you're inheriting property and trying to clear the title, or if you're a homeowner yourself. Now, if you're wondering, I've just kind of gone over all of those exemptions and you're wondering, well, I'm not sure based on her descriptions what exactly I am eligible for. You can go on our website we have something called the Exemptions Wizard, which is basically a questionnaire that will ask you a set of questions about your home. And then based on those, it will tell you which exemptions you are most likely eligible for. So if you have any questions, feel free to go to our website at www.hcad.org. And it also will allow you to fill out the forms at that point online once you go through that. So that should be something a tool that should hopefully be valuable to you. Quickly, I want to go over this because sometimes it can be very confusing in terms of what you're actually paying for. And my colleague, again, Shay, is going to probably discuss this a little bit more in just a minute. But I do want to make sure that we always run across something that property owners often find confusing, especially some of them are property owners that have been living in older neighborhoods for quite some time. We talked about the exemptions. Exemptions are something is that discount on your annual tax bill, that if you're eligible for those, you will apply for them. Once you no longer are eligible for them, once that property is no longer eligible for them because it's changed hands, the owner's deceased, or it's been sold, those exemptions will come off. They terminate when there's a change in ownership. And that new owner would need to go and apply for them again based on what their qualifications are. Now, there is something that called a tax deferral that you can also get if you're over age 65. Many people confuse the two because when they talk about the tax bill, the tax deferral is something that is administered to property owners, can be administered to property owners over 65 if they so desire. And that's simply an agreement that they make to defer or postpone their property taxes. Legislature put this in a while back because so that senior citizens who may be on a very fixed income don't have to choose between paying their taxes or paying for their prescriptions or paying for food. They can simply postpone those property taxes and they would not lose their home because of any tax foreclosure or whatever. Those tax deferrals will terminate upon the death of the property owner or a change in ownership. So that's something that heirs really need to be aware of, whether or not there was a tax deferral on the property at that point. There may be a tax bill out there for them already. So that's important to remember if you are inheriting property. The exemptions confirmation card is a good way to remind you to remember whether or not you have exemptions that are correct on your account here at HCAD. We send this out every December. It's a little postcard that comes out. It's sort of like your annual checkup. Gee, are these the exemptions I'm supposed to have on this property? So be on the lookout for that in December, early January, and just take a look at the back. If it's correct, throw it in the drawer. You don't have to worry about it. If it's not, that's your reminder to get with HCAD, to contact HCAD to make sure that the exemptions that you are eligible for and that you apply for the exemptions that you're eligible for, or you change the ones that you are not eligible for. Questions, please feel free to contact us. I know I've gone over a lot, and again, exemptions can come with a lot of different conditions or situations, circumstances that a homeowner may have. So if there's any confusion, please feel free to give us a call at the number you see on the screen, or you can go out on our website. We have a number of helpful information out there, whether it's maps. You can do property searches to find out what your exemptions are on the property. If you want to have hearings, we have workshops and other events. We also have a chat feature that you can talk directly with staff, not a bot, at certain times during the day. And then, of course, you have your online owner's account where you can contact us directly at hcad.org/contact us form. So those are just some of the things that hopefully you can roll into what Lisa has told you in terms of making sure you've got all of your ducks in a row when clearing property. And again, I appreciate you all listening to this, and feel free to share that information with your neighbors and colleagues. And thank you all so much. And I'm going to now turn this over to Shay.
All righty. Thank you, Miss Mabel. Good afternoon, everyone. If you weren't here at the beginning, my name is Shay Pinkowski, and I'm with the office of Annette Ramirez, who is our Harris County Tax Assessor Collector. Let me make sure that everyone can.
Miss Mabel, you have to undo your screen share.
Okay, I thought I did. Oh, stop share. Okay. Go.
Go ahead, Shay.
There we go. All right. So just to make sure everyone can see my screen okay?
Yes, ma'am.
Perfect. All righty. So I'll just go ahead and go right into it. We are the Harris County Tax Assessor Collector's Office, and our tax assessor collector is Miss Annette Ramirez. What does our office do? We do quite a few different things. What I'm mostly going to speak about today is the property tax process, but just so you are all aware, aside from collecting property taxes and sending out those bills at the end of the year, we also register our voters for Harris County, and we process essential auto services. That's your vehicle registrations. That's making sure that your sticker is up to date, providing you with license plates, transferring titles of your vehicles, and making sure that those titles are being processed with the correct information. So if you've ever had to transfer a vehicle into your name or update your registration with a new address, more than likely you've had dealings with our office before. So the property tax cycle goes in the same order every year, and it begins with the appraisal phase. That is when the appraisal district will go and make its determinations on what the appraisal value of your property is. That typically lasts from January till May. The equalization phase is something that we speak on in another presentation, but it is the portion of the year in which the taxpayers, meaning the owners of the property, the owners of the business, will go through a phase called equalization. They're able to go and protest the value of their property. They're able to see what the values that are being provided to them from the appraisal district are, and they're able to contest whether if they believe that that value is incorrect. Say if they believe that the value of the property is not accurate, they would go through this process called a protest. And Ms. Mabel did mention that a little bit further into detail. We do have other presentations about it throughout the year. So, if you have further questions about that, please let us know. The following phase is the assessment phase. This is conducted by the governing bodies. You'll hear the governing body referred to as a couple of different things, including jurisdictions, which are the entities which collect taxes for the essential services that they provide. So this will come from Harris County. This will come from Harris County Port Port Authority, hospital districts, Department of Educations, your schools, your MUDs, several cities as well. All of them determine at what rate they collect their property taxes on between July and October. And that's when that process goes through. And the final phase is the one that we're the most and that we are the most named in, and that's the collection phase. We're the office that bills out a statement. We send you a bill in the mail. We're the office that collects your property taxes, and we're the office that distributes those paid taxes to the governing bodies that provide us with those essential services. So the Harris County Tax Office is the office that sends out those bills, receives the payments, and then disperses them to the necessary jurisdictions. And then the cycle starts all over again. That typical collection phase begins in November when we send out those bills. And it's to June, but honestly, we collect throughout the year. But in June is when we start turning those accounts over to delinquent attorneys. So that's typically when our collection phase is. Your tax bill is calculated based off of a couple of different things. The principal one is going to be the appraised value of your property, which is determined by the appraisal district. We then subtract any applicable exemptions from the value of the appraised value of your property. And that's how we determine what your taxable value of your property is. That's your appraisal value minus any exemptions is your taxable value. We then multiply that by the tax rate, which is determined by each jurisdiction individually. So every jurisdiction, every governing body has their own regulations and requirements for exemptions. And they have their own budgets that they have to adhere to in order to have the correct amount of taxes paid to supply us with these essential processes. And when they determine their tax rate during that phase that I spoke of earlier, that is where we determine, or they determine their tax rates. So we at the Harris County Tax Office take your taxable value, we multiply it by the tax rate, and that's how we determine how much your actual bill is. So on your statement, whenever you get those in the mail, you'll see your appraisal value, you'll see your exemptions, you'll see a tax rate, but this is the calculation that determines how much that actually ends up showing on your bill as what's due. There have been several recent property tax law changes, and this doesn't even necessarily include the new exemption for properties destroyed. Oh, yes, it does. Excellent. Okay, so exemptions have increased over the course of the past couple of years, including the school general homestead exemption, which increased from 100,000 to 140,000. Your schools over 65 and disabled homestead exemptions increased from 10,000 to 60,000. As well as expanding exemptions for surviving spouses of veterans whose death is due to a service-related condition. And business personal property exemptions were up to $125,000 for the 2026 tax year. So lots of changes are going on, and they're going on continuously. So whenever you're, reading the newspaper, watching the news, keep an eye out, see what is being put on the ballot, because every November something new comes up, and it's always best to stay informed and know what you're voting on. Reducing your tax burden. So you, as a taxpayer, are required to pay your property taxes. Now, we aren't able to discount them directly, but the way that you are able to lessen that burden is by applying for exemptions that are applicable to you. So if this is the home in which you own, you live in, you reside in, it's applicable for a homestead exemption. Now, if you are also on top of the owner of the property that you live in, and you are over the age of 65 or disabled, you also can qualify for an over 65 or disabled exemption. Now, this little chart is handy in the way that it shows us exactly or approximately how much that change can be monetarily. So on a property worth $400,000, your typical tax bill would be somewhere in the realm of $8,500. With the homestead exemption, that brings it down to about $5,500. And with homestead and over 65, it goes down even further to 1,516 approximately. This is not including any differences with the tax ceiling or tax freeze, which I'll talk about here in a little bit. But it is a good starting point to kind of have an idea of how much of a difference it can make. So you're not avoiding or not complying with getting your exemptions when in reality it could be a very great benefit to you. So just a little show of how much of a difference that can make on your property taxes. Taxing limitations. Ms. Mabel mentioned it earlier. I mentioned it just a second ago. They'll come by a lot of different names. You'll hear them referred to as a tax ceiling, a tax freeze, a tax limitation. It all boils down to the school tax, the property taxes that you pay towards your school, such as HISD, PISD, any other Texas independent school district, along with a handful of other jurisdictions, allow for something called a tax ceiling. And that tax ceiling is essentially going to benefit those who are over the age of 65 and homeowners of their property. So they have that homestead and that over 65, or that homestead and that disabled exemption. And what it does is it freezes the taxes at the amount that was paid the year you turned 65 or the year that you were granted that disability exemption. And essentially how that plays out is when you are paying your taxes for the first year, you don't really see much of a difference. But the following year, if, for instance, the initial year your property taxes for your school were $300, and the following year, due to the values of your property going up or changes to exemptions or, you know, anything of that nature that would increase your property taxes, that tax ceiling, so long as you have that homestead and over 65 exemption, would freeze your school tax at $300. So even if the value determines that those taxes should be due in the amount of about $500, because you have that tax ceiling, and it's automatic, it's not something you have to apply for, but because you have that tax ceiling on your account, you would pay $300, and that's how much you would be billed for. So if you're ever looking at your property tax bill and you see that that value doesn't quite make sense with the math that we just explained, more than likely that's the cause. But of course, you're welcome to give us a call and ask directly if you have any particular questions. But as I mentioned before, you don't have to apply for this. It's automatically granted to your account whenever you have that homestead and over 65 or homestead and disability exemption on your property. Another great benefit that we have when you apply for your homestead and over 65 exemption and you have those exemptions on your account is something called a tax deferral. Now, tax deferrals are something that you have to apply for through the Harris Central Appraisal District, but the purpose of it is for it to be a postponement of your taxes. Essentially, when you apply for a tax deferral, you're applying to postpone the payment of your taxes. What does this do? This gives you additional time to pay your taxes without having to pay as much penalty and interest as you typically would be required to pay. So normally those property tax penalty and interest come up to 7% with the first month late penalty. Second month is 9, third month is 11, and it continues to accrue with time. With the tax deferral, you are collected a 5% interest per year on unpaid balances, and that is it. The deferral ends upon the sale or change of property ownership, meaning that if the property owner decides to downsize and instead of living in a home, they would prefer to live in like a condo, an apartment, that deferral is no longer active, it's no longer applicable. So for instance, if you live with your mother and father or your mother, and your mother decides to move out of that home into something smaller, or unfortunately, if she passes away, the property taxes would still be collected on as normal. That deferral is no longer applicable. So it's not a cancellation of taxes. Those taxes don't go away. Whatever taxes are owed are still owed, but they're owed with a lesser interest and no penalty. And they allow you to have a little bit of extra time in which to make those payments. So you do have to have the homestead residence exemption along with either the over 65 exemption, the disabled homeowner exemption, or the disabled veterans exemption. It does have an important note here that if you are still making payments toward your home, please make sure that you consult with your mortgage company before you submit a request for a tax deferral, as because of the fact that they have a vested interest in your property, they may not allow you to have that tax deferral because, as I mentioned before, those taxes are still due. And I do like to kind of hark on this just a little bit. If you have a tax deferral on your property and you're living in your property, please make sure that you are notifying your heirs, notify whoever is going to come into the ownership of this property after you're gone, because those property taxes, as I mentioned before, they don't go away. Those taxes are still due. So if you go on not paying your taxes because you have the deferral and you don't have to worry about that affecting you negatively, you are able to do so, but it causes further harm for your heirs later on if they are unaware of it. Upon the removal of the deferral, your next of kin would have, or the next owner of the property would have 181 days in which to pay the tax deferral or the taxes due with the tax deferral rate, after which you are assessed penalty and interest as if that deferral were never on there. So if it's a couple of months, it's not such a big number. However, with time, that can get kind of excessive. So please make sure you're letting your heirs know. It's always better to have them be informed and then possibly making adjustments to make your payment of your property taxes on your behalf, or get together with other heirs that might be involved with the property later on. Say, hey, let's split the property taxes so that we don't have to worry about it afterwards. But just make sure that everyone is aware. Have that conversation. It's not an easy one, but you should still have it. And make sure that you're making those payments on your property taxes before that deferral rate comes off, because 5% doesn't look like a whole lot, but then you see it over the course of, several months, years, and it does get quite high. One more option that we have for our homestead over 65, homestead disabled owners, homestead disabled veterans, or the surviving spouse of either, is something called a quarterly payment plan. Quarterly payment plans are very helpful in making property taxes for those who are on a fixed income, but they don't necessarily want the deferral. They don't want to postpone their taxes. This is still an option for you. There's no penalty or interest that apply to this so long as the payments are made timely. And this can be applied to the current year's paid taxes. So how this works is whenever you get your statement in the mail, typically around November, your property taxes are due at the end of January. In this case, when you're applying for a quarterly payment plan, you would make your first payment in the amount of 1/4 of your total due. So you would divide your total bill between 4 equal payments, with the first one being due at the end of January, the second payment being due at the end of March, the third being due at the end of May, and the fourth being due at the end of July. Now, this does have to be approved for exemption status. You do have to have those exemptions on your property to qualify, but it is an option for those folks who are in their homestead and over the age of 65, disabled veterans, or their surviving spouses. And it is very, very helpful for those who have those limited incomes that we discussed earlier, in making your payments timely, but not necessarily being on a deferral and having to have that concern for later. But just so that you're aware of what your options are, this is something that you can request directly with our office, or you can just make your first quarterly payment in the mail whenever that bill becomes due before the end of January. Now, for those of us who do not apply for that over 65 disabled homeowners or disabled veterans or their surviving spouses, we also have delinquent payment plans. Now, these payment plans do assess penalty and interest fees, but they do allow you to have additional time in which to pay your property taxes before going into delinquencies and attorneys collecting on the behalf of the county. So whenever you become whenever you set up these delinquent payment plans, you are assisting yourself in avoiding those additional fees that come on after June. As I mentioned before, whenever we have those properties handed over to the delinquent collection firms. But we do offer those for any kind of property. This can be for homestead. This could be for a vacant lot. This could be for business personal property. Anything under the sun. If you owe property taxes on it and you would like to create a payment agreement, please contact our office or log onto our website and create a payment agreement for yourself. And that way you can be aware of your property taxes and show that you are making those good effort payments. So our website has recently gotten an update, which has made it really, really convenient for a lot of different reasons. Some of my favorite being that you're able to set up your prepayments. You can now have reminders of when your statements are due. You can make your payments securely by saving your contact information in the system itself. And you can view your receipts at any time whenever you've created this account. Any of the receipts for payments that you've made with that account information will be on there. And I do believe that it is super helpful. I myself use it whenever I pay my property taxes. One of the things that we have that is relatively new is something called a prepayment plan program. And what that is for those of us who, we make sure that we pay our taxes by the end of January every year without fail. But, getting that statement at the end of the year can be a little scary. Some of the taxes, depending on where you're located, how much your property is worth, can be pretty high. So one of the options that we're offering now is the ability to begin a prepayment program, which essentially would take the total amount that you paid in property taxes last year as an estimate. So we take that value, we divide it into however many months are between when you're beginning this payment agreement and October. So right now we're in August. Well, there's 2 months between now and October. So it would divide it into 2. And if you don't pay those amounts, nothing happens. There's no penalty. There's no interest, no fees for it. But for those of us who begin it a little bit earlier, say February next year, our 2026 taxes are paid. Now we're looking ahead to 2027. And, instead of paying all in one lump sum at the end of January 2028, we would prefer to pay, smaller increments between February and October. That is now going to be an option for you. And of course, you can set those up on our website. You can also set up reoccurring payments. If you are making a payment agreement and you are aware that that payment agreement is required to avoid delinquency on your property taxes, you can set up reoccurring payments instead of having to think about it. Oh my goodness, I need to pay my taxes every month. Those reoccurring payments allow you to schedule those, and you get notifications in case, say, you change your debit card and forgot to change it on the website. It'll let you know, hey, this payment didn't go through. Please make another payment. So it's really super helpful. I've left the QR code up there a little bit, but if you, again, would like to check this out afterwards, it's also on our website and you can reference it from there. So aside from making payments on our website, which is, in my opinion, quite convenient, you also have other options in which to pay your property taxes. This includes sending your payment in a check or money order to us in the mail. This includes paying by phone through an IVR system or by coming into a branch office and making a payment in person. Any of our branch offices are able to take payments, and they're all ready and willing to assist you. There are some additional notes that I would like to leave you with just so that you're aware of it. Credit cards do assess a fee of 2.4%. You do not pay any additional fees if you pay with a check or with cash, although cash is only accepted at our branches. And an e-check payment, which is an electronic check payment through your bank, which can be done on our website, is 50 cents additional. So you have many options to pay. If you are unable to make it into an office directly, I highly recommend you attempt to make your payment online or by phone. Or if worst case scenario comes to worst, you can go into a post office and mail in your payment. Just make sure that if you do, that you get that payment postmarked so that when it gets sent in the mail, even if it takes a little bit of time to get sent in the mail, because our post office does that on occasion, but just in case, you have that postmark date of when you drop that payment off. And so long as that postmark date is correct, then that's the date at which you would receive your payment. So many options. And of course, if you have questions, please feel free to give our office a call. Our office is committed to reducing your tax burden. Now, while we cannot affect how much you pay on your property taxes, what we can do is we can assist you in making payment plans, providing workshops to assist with informing the public, prepayments, and giving you the option of receiving your bill in other ways that you might not have had before that might be more convenient to you. So instead of getting those bills electronically, getting that set up on your website so that you can receive your statement through an email instead of having to wait for it to come to you in the mail, and having those delays. These are all things that we're able to assist you with and that we're making great efforts and strides in trying to make this happen. But of course, we're happy to assist. If you have any questions, please feel free to give us a call or send us an email, or if necessary, send us a fax. But our information is up here at the front. And of course, our website has a great deal of information as well. So if you have any questions, you could probably look that information up as well if you don't feel like speaking to someone directly. But that is the end of my presentation. Miss Nia, would you like to come back on while I look through the chat to see if we have any questions?
Yeah, there are a few questions that are in here. I haven't seen any that were related to tax bills, but Miss Lisa and I believe Miss Mabel were addressing a few of those. So one question in particular, and I'm going to kind of paraphrase this because I don't want to give all of this detail. If a husband and wife had a house that was paid off, and they currently live in the house, but they are legally divorced, but had no children. But the wife had a previous child, but they both want to leave the house to the child, not child, as an adult. So I'm not gonna say child because not a child, but
Adult
the
child.
adult daughter. What happens there? What's the best way to?
The best thing to do is a transfer on death deed. If they both own the home, they both need to sign the transfer on death deed, and they can both leave it to the adult child. In general, I am always going to say transfer on death deeds because you don't have to go through the expense of probate. It's easy and it's very quick. And Miss Nia will let you know she hosts a lot of Todd clinics where she can help the homeowners out.
And we actually have a will clinic that's coming up, but I'm going to get
Awesome.
into that in just a little bit. Let's see. Another. Can a quit claim deed be used to obtain ownership of family property?
No. I highly recommend we have had real estate attorneys give presentations on deeds, and I recommend going to those. Quit claim deeds are not worth the paper they're written on. All that it does is it says I could write a quit claim deed to Miss Nia's house, giving all of my rights to Miss Nia's house to you. I don't have any rights to it, but a quit claim just says I give you any rights that I have. It doesn't say I give you the property.
Okay. Which is another reason we also recommend that you never, never, never purchase or do any kind of real estate transactions without going through a title company. Please,
Please,
I
please,
will
please,
please.
please.
Please, please,
Please.
please. It will lead to heartache, and any money you think you save, you will spend many times that dealing with the problem in the future. Um,
Yeah.
I'm an attorney on a website that's called texaslawhelp.org, and it has a lot of information and forums about civil legal problems. We will not, we do not, and will never have deed forms except for the Todd, because you should always have an attorney prepare a deed. Because if you make a mistake on a deed, the person you deeded it to does not have clear title, and it's very easy to make a mistake.
Okay. I'm looking on the internet too, and then my emails that
Oh,
were
yeah.
sent to me in advance. I was doing both of them. Let's see. I thought this was very interesting. Um, the question that you had here, father passed away with no will, um, but he's a shareholder in a family LLC in Louisiana, and there's financial distribution from the LLC. what needs to, what do you need to do to have the LLC issue the money to the father's next of kin?
That person needs to get, I do not practice business law. They need to talk to an attorney who specializes in business law to determine how to do it because it would depend on the way the LLC was structured. It's pretty complicated. It's not something that I would recommend doing on your own.
Yeah, and I thought it was interesting that she said that the law firm that did the LLC told her that it needed to be handled in Texas. And I've never heard of an LLC in Texas operating in Louisiana.
The only thing that I can guess is that because he passed in Texas, probate needs to happen in Texas, and
Oh,
government LLC, any type of corporate entity is formed according to federal law, not state law. So I made a
gotcha.
mistake when I told her to talk to an attorney in Louisiana.
Oh, no, I think she said she talked to an attorney in
Yeah,
Louisiana and they
and
told her
they
that it
said do
needed
it
to
in
be handled here.
Texas.
Okay. All right. Got it. Got it. Got it. Got it. And then most LLCs have an operating agreement though
Correct.
that kind of goes through how distribution is typically handled in the event of
Yeah,
dissolution or something like that. So
that's why you need a business law attorney to look through the operating agreement and any other documentation that they have.
okay. Let's see. Miss Mabel. And I think you did cover this one too, but I just wanted to address it because there are a couple of people that I see that are only on the phone. I don't know if they can actually see the chat or not, so I wanted to go over these. Do exemptions expire upon death of owner or when the probate is settled?
I think I answered that they
Mhm.
expire upon the death of the owner, or if there's a change in ownership, and they expire that next January. So if a person dies in June, then the exemptions will actually remain on the property till the following January. It could be, and this is important, it could be that the once the property changes hands, it may take a while for that person to uh get the information to HCAD, which is why I say that it's important to kind of keep that as an additional page in your head, I guess, in terms of what you need to do and for clearing title once a person passes, is that property tax piece, and we do send out that annual confirmation card each year in January, which in December, which explains what the exemptions are, and that should come to the residents. If it doesn't come to the residents, then that you may want to just double check with HCAD, but kind of always you want to include HCAD in your toolbox in terms of making sure that you handle all of the business necessary with when clearing title. Would you not agree, Lisa?
Absolutely. And I highly recommend if you have questions about your property taxes to go to both the HCAD website and the tax assessor's website. Both of them have a lot of really good educational material. Both articles, videos, how-tos, they're both really excellent websites for property tax and for all kinds of taxes for the tax assessor.
And then we'll be back with the tax office on August the 26th as well for another presentation. So you guys will receive the notifications about that. Uh, let's see. Another question here before I get to the emails. Is an attorney needed to complete a TOD?
And I apologize to the person who asked it. I didn't mean to sound so definite like that. I didn't realize my cap locks were on, so I didn't mean to seem that way, but absolutely
Why
no.
are you yelling?
I didn't mean.
In your defense, I read it as excitement. I was like,
Oh,
no.
thank you. 'Cause maybe that's what it was subconsciously, because no, Todd's are terrific because you don't need an attorney. You can do it yourself. The only thing that's critical is that you have the property tax description, I'm sorry, the full legal description on the deed, and you can get that from the county clerk's office. but you do not need an attorney. If you can make it to one of the Todd clinics that we have, I highly recommend it because you will have people helping you because there is some language on the Todd that even I think is a little confusing. So it's good if you can get some assistance, but you absolutely don't need it.
Okay, which brings me to a question that was emailed to me. A Todd, once an affidavit of death is filed, do I still need to do an updated Todd or get a new deed made?
The affidavit of death, along with the Todd, is proof that you have clear title to that property, subject to
But
whatever loans were on it. You don't, I mean, you can go to an attorney and ask for a deed, but it's not necessary.
okay, because somebody had actually called our office and she's like, I went to file the affidavit of death because there's a lady that had come to the Todd
Mhm.
clinic back in March,
Oh, great.
and she said that that her husband unfortunately passed away, and she needed to go file the affidavit of death. But the person at the clerk's office was telling her she needed to get an attorney now to draft a new deed. I'm like, mm, I've never heard of that. I said, you definitely need to come to this presentation to hear what
Yeah,
the response is. I said, I'm assuming that from my understanding, everything just got attached to show like the chain of
correct.
title. But I said, but if you wanted a new warranty deed, help yourself, but still come
Mhm.
and ask the
Yeah.
question. So
Um,
so it is not required.
it is absolutely not required.
Okay.
I'm surprised the clerk said that because they are not allowed to give any legal advice. They are not attorneys. And it's usually clerks err the other way, where they won't give people any information because they say I can't give legal advice when it's something really simple. But yeah, don't take advice from a clerk unless they tell you they're an attorney.
In the defense of the clerk's office, a lot of times people go in and well, they said or they told me, and they completely misunderstand a lot of times what instructions come
Sure.
afterwards. So I'm not putting anything on the clerk's office, just to kind
Thank
of clear
you.
the air there.
Yeah,
But
that can absolutely be true.
it can and it happens a lot, especially when people are trying to handle someone else's affairs. And in each of these sessions, I always recommend to people, especially when we're talking about the what happens after someone passes, to allot yourself some time to grieve and go through the process of the grief period, however long that takes before you try handling some legal affairs and financial affairs and things of other people, because it's very stressful. And while you're
Yeah.
going through that stress and then trying to grieve at the same time, it becomes a lot of work. It becomes a whole lot of
Yeah,
work.
please give yourself some time. I can, both of us are speaking from personal experience. You need to give yourself some time to just deal with your loss. It doesn't have to happen immediately.
When you've got some, we had this call earlier, and if you've got someone that passes away that's married, that is estranged from a child or children, and nobody knows where they are to distribute any kind of assets, or if they wanted to sell if the mom wanted to sell the property or what have you, how do you contact what happens when there is no contact with the estranged children or child?
That can be really tough. If they have a will, they
There is no
certainly,
will, no will.
yeah, okay, that gets really complicated because if there's no will, that estranged child legally has to get notice. And if they have no idea where they are, it's a real headache. I had a probate many years ago where there was a child that no one had heard from, gosh, 20, 30 years, something like that. And the family members believed that he was dead, but they didn't have any proof of it. And it took a long time to get that estate distributed since there wasn't any way to contact that person or to find out
Mm,
if they were had passed.
wow. So where does somebody even start with something like that if there are estranged heirs,
Have a
not even
will,
necessarily
leaving those
children?
heirs out. And if there is no will,
Okay.
set aside a lot of money for attorney's fees because it's going to be a long and complicated process.
Wow. 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 Wow.
Because I mean, if there's no will, the law assumes that every single person, every heir, is entitled to a portion of the estate, and the judge cannot move forward until they've determined the status of that heir.
And I guess this is a similar question. How do you clear title for clear a deed or title for a deed when there hasn't been a probate in over 3 generations?
Affidavit of heirship. And lots of times we had this when I was at Earl Carl. Someone had bought this property in something like 1908, and there were many, many, many heirs, and the family ended up having to save money to get a genealogist to figure it all out. But you
Wow.
need an affidavit. If you were in Harris, any of the counties adjoining Harris, so Harris, Fort Bend, Galveston, Brazoria, Liberty, and I'm probably skipping something. Galveston. Earl Carl Institute specializes in this Earl Carl Institute Property Preservation specializes in these types of issues. It is income limited, but if you qualify, they do a great job.
Let's see. Father died, and siblings are trying to get me to sign some papers. What do I do?
Get an attorney to review it. If you don't trust them, if you don't understand what they're asking you to sign it, absolutely do not sign it till you have someone, a neutral person, explain it to you.
Okay. Do, 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 do. Okay, and then the affidavit of heirship, and I have a copy of that form that you gave me, Miss
Great.
Lisa. Somebody had the question, how do I get a copy of an affidavit of heirship when there are multiple heirs? I will be sending out a copy of any documents or anything that Miss Lisa has reviewed here today. What she talked about, letters of testament, or not letters of testament, oh my goodness, don't I say that? Affidavit of heirship, we talked about the Todd form. Those things I will send you out a copy of so that you can review those. In our previous sessions, we talk about the wills and estate plan and other documents that make up an estate plan. We do that presentation the first Thursday of each month. I will include that link for you all to go back and watch that presentation as well so that she can review or go over those documents and explain how they work and what you need to do with those. But again, that was kind of like part one of this session. Those are all the questions that were emailed to me. I just wanted to make sure that those were addressed. And I don't see anything else
Somebody
on
put
social
a
media.
question in the chat just now on, I told them to please email me. It's far too complicated to get in here and would involve too much personal information to have online or recorded. You can contact me or contact Miss Nia, and she knows how to contact me. You're going to need an attorney, but I'm glad to talk you through a little bit about what's going on.
Okay, I would assume that was a personal inbox that
Oh, it
message
sure
you that because I
was.
didn't see it. Okay,
Okay,
all
it's
right.
a personal message. So
Okay,
so this person can email me and
okay.
can put them in the right direction.
All right. And Ms. Lisa's email address will be included on the email that I sent to all of you. A copy of this recording will be included as well. Again, we do these presentations the second Thursday of every other month. So next month, we actually have our next session, we have to move our meeting to October the 15th, but you all will receive the notifications about the upcoming meeting. So if you guys would like to come where we are in person, or if you are interested in having other family members or somebody to attend, or if you want to come back and get more information or you have other questions, then please feel free to join as often as you need to get as much clarity as you need for whatever the situation may be. We definitely recommend or ask that you pay it forward and help circulate this information as much as you can. Um, and I tell folks all the time too about listening to the street committees out there and the law and order attorney fans that that know everything about the law, that have never gone to law school or experienced any kind of courtroom proceedings in the state of Texas. A lot of times, a lot of that information that's available on social media is not relative to the state of Texas. It does not apply to Texas probate estate planning laws. So please make sure that you vet your sources and where you are receiving the information from, and do your research so that you're not getting forms offline from someplace else, or what's the thing where people get the legal forms online. I can't
Like
remember.
a legal Zoom.
Legal Zoom
And there's
and
a
things.
new one that's called something like estates and trusts, or I can't, it's something
So,
in trust.
yeah, when you're
Please
filling
don't
out,
use that.
if you're filling out all of those forms online, please do not do that, because those are not valid forms for the
No.
state of Texas.
I
So,
I can tell you so many stories of families that ended up spending everything on attorneys because the parent just wanted to do something cheap off online instead of paying for an attorney to do it. And those are not those. If anybody argues, the judge cannot accept it for probate, and it goes through a very slow and incredibly expensive process.
yeah, and know that the probate process itself in Texas, well, when you were talking about trust, um, and even probate court, we was all of 15 minutes when I had to do it for my dad. Like literally, hey, I am who I am. This person passed this day, and you're who you are. I'm Nia Murray, and okay, and
Mhm.
we were done. That was it. So if I would have had to pay for trust and all the other kinds of stuff for 15 minutes in court, I would have been so upset.
Thank you.
I would have
People
been
do
so
not
upset.
understand it. Probate is very simple. There are other states where it is not. But if you have a good will, it's simple, and people get it in their head that they have to have a trust. I get this question anytime I'm out in the public, and I say there are only a few reasons when you need it. Most of the time, you're spending a lot of money you don't need to spend.
And one more thing, Shay, if you could reiterate again, how much time does someone have if they've had deferred property taxes from the time that someone passes away to actually get taxes paid?
They have 180 days to pay. On the 181st day, they get assessed with regular penalty and interest instead of the 5% interest per year that they would have had during the deferral. So
So
180 days.
So if you
6 months.
guys know of neighbors and family members and friends and relatives that are still living in a relative's home that has not been discovered yet by HCAD or somebody that the person has passed, and they've had deferred property taxes or have not paid taxes in however many years since the person has passed, you are due for a substantial uh, penalty, interest, fees, bills, taxes that are due
Mhm.
once it gets reported.
Yes. And
I
it,
had a lot of clients that didn't want to change their HCAT account because they liked that senior citizen exemption. You will regret it. You will get found out, and you will have very significant penalties that would be a lot more than what you would have paid if you had done the right thing in the first place.
And FYI, we have our property tax foreclosure workshop that's on every other month as well on the fourth Thursday. So if you find yourself in that situation where you're getting foreclosed on because of unpaid property tax bills and deferred property tax bills, then please make sure that you tune into that so that you can understand, what that process is like and know where your rights are and where you can go for assistance. But for the purpose of estate planning and helping with protecting your assets, our organization does do we Todd clinics. I try to do them at least once a quarter or so, depending on the availability. We have volunteer attorneys that come out and give a presentation strictly about transfer on death deeds and how they work, how the forms get completed. We help with having attorneys to review those documents, to help filling them out, finding your property tax, your property legal description, your getting the document notarized, and even in most cases, getting it filed for you if you income qualify. So that those folks, because a lot of them too, and a lot of the past ones, we've had people that go and they get the Todd completed and they never go down and get it filed. Never, 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 never go and get it filed. So completing a Todd and not filing it does you absolutely no good whatsoever. So, but it is quite difficult for a lot of seniors to get downtown, to go and find somewhere to park, pay for parking, to walk back to the building, the clerk's office, and get that file. So we do offer that service sometimes, if funds allowed, that we do that for you as well. So be on the lookout for our future Todd Clinic next Saturday, actually on August the 22nd. We do have a simple will clinic that's going to be held over at the East Houston Civic Club. I will be sending out the information to all of you guys as well. Again, where we have built volunteer attorneys with the Center for Heirs Property leading the volunteers to help with creating simple wills for folks. There is no income limit, income qualifications, or anything like that for that service to get done. So if you guys have a simple will or in need of a simple will to be created, then please let us know, and go online to register for that. But again, I'll be sending you out the link. One of the requirements is that you had to have been a participant of our presentations, either this session or past presentations, not just a person kind of coming in off the street and wanting to volunteer. So register with us for that. I will make sure that you get your appointment set up to come in to have your will created, and you will walk away with a will that day. So that'll be sent to you guys as well. Following this session, again, that link pops up on the screen. If you could just take a couple of minutes to review and to complete that survey, we would greatly appreciate it. If you all have any other questions or need any or the additional assistance, please feel free to reach out, and I will make sure that your particular issue or whatever it is that you're facing gets referred to the correct resource or service. I may not know all the answers, but I will definitely do my best to find you the next available resource or expert to assist in your situation as I can. So, Ms. Lisa, Ms. Mabel, Ms. Shay, Ms. Cecile, thank you all very much for joining us this afternoon. We definitely appreciate your continued support and partnership with the A Month of Service collaboration. So for all of you guys, you all have a wonderful remainder of your day. You all take care of yourselves. You stay safe, and we will see y'all next time.
Thank you,
Thank you so
everybody.
much.
Thank
All
you.